Take a look at this diagram. We have two physical commercial warehouses, Unit 1 and Unit 2. Both are owned by a single freeholder named Fiona. To fund her business, Fiona took out two separate loans. First, she secured a legal charge against both units with Mercantile Facilities plc. 2 months later, she secured a second, subordinate legal charge against the exact same properties with Premier Finance Limited. Both of these units are currently occupied by commercial tenants, and each is operating under an entirely separate, distinct leasing timeline. A few months go by, property values in the area drop, and Fiona's cash flow dries up. She falls into arrears on her second loan and defaults entirely on Premier Finance. This setup poses two questions. Can Premier Finance evict those commercial tenants to force a sale? And if they do, who actually gets paid first from the proceeds? Resolving a physical dispute over commercial land requires navigating the strict hierarchy of proprietary rights, as a breach of a loan agreement is distinct from the property interests attached to the land itself. A mortgage operates simultaneously in two legal spheres. It is a personal, contractual promise to repay a debt, but it is also a proprietary security interest attached to the borrower's land. Because it attaches to land, creating a legal mortgage requires strict statutory compliance. Under Sections 52(1) and 85 of the Law of Property Act 1925, the mortgage must be executed by a formal deed. For registered land, execution is only the first step. Section 27 of the Land Registration Act 2002 designates a mortgage as a registrable disposition. It only achieves legal status once it is entered into the title's charges register. If a lender fails to register that charge, the mortgage fails as a legal estate. It survives only as an equitable interest, which is less enforceable against competing third-party claims. There is a practical difference between the contractual debt and the proprietary security. If an insolvent borrower defaults, a personal lawsuit is ineffective. The lender's recourse depends on the execution of property remedies against the land. To prove a bank has the right to use those remedies, you must cite the specific statutory requirements, the 1925 deed requirement and the 2002 registration requirement. Strict compliance with these statutory formalities is the prerequisite for a lender to exercise property-based remedies against a defaulting borrower. The most immediate remedy available to a mortgagee is the right to take physical possession of the land. As established in 4 Maids Limited versus Dudley Marshall, the right to possession arises as soon as the mortgage is completed. The borrower does not need to be in default for this right to exist. However, statutory interventions restrict how this theory plays out in reality. Section 6 of the Criminal Law Act 1977 applies directly to these physical repossessions. Under Section 6, using or threatening violence to secure physical entry is a criminal offense. This requirement generally leads banks to seek a formal court order before attempting to recover an occupied property. The law also distinguishes between commercial properties and residential dwellings, which are governed by Section 36 of the Administration of Justice Act 1970. Section 36 allows a court to pause an eviction order for a residential dwelling if the borrower can repay the arrears within a reasonable time. Since Fiona's properties are commercial warehouses, they do not qualify for this statutory protection. While the common law recognizes a lender's right to possess, statutory protections frequently necessitate court oversight before that right can be physically exercised. Because physical possession entails specific liabilities, commercial lenders typically rely on the statutory power of sale. To execute a sale, the power must arise, then become exercisable. Under LPA Section 101, it arises once the legal redemption date passes, usually 1 month post-mortgage. It becomes exercisable under Section 103 only after a default, like interest falling 2 months into arrears. Once a bank meets both criteria, they can force the sale. However, equity imposes a specific duty on the lender regarding how the transaction is conducted. In the case of Cuckmere Brick Co. Limited v. Mutual Finance Limited, a lender forced an auction but failed to advertise that the land had planning permission for flats. This omission resulted in a lower sale price. The court established that while a bank can choose the timing of a sale, they must take reasonable care to obtain the true market value of the property at that date or account for the financial difference. The power of sale provides the lender with liquidity, but it is accompanied by a duty of care designed to protect the borrower's remaining equity in the land. The focus shifts when multiple banks and commercial tenants claim overlapping rights to the same registered title. Disputes between competing mortgages are governed strictly by Section 48 of the Land Registration Act 2002. Under Section 48, priority is determined by the chronological order in which the charges are entered onto the register, not when the loan agreements were initially signed. This hierarchy controls a forced sale. Under Section 104 of the 1925 Act, a subsequent mortgagee sells the property subject to any prior registered mortgages. For non-lender third parties, Schedule 3 of the 2002 Act provides that legal leases of 7 years or less take effect as overriding interests, which bind subsequent purchasers or lenders. The validity of a tenant's interest depends on the specific date of the mortgage's registration, rather than the date a lender eventually seeks repossession. A mortgagee's ability to clear a property is ultimately subordinate to the mechanical, chronological rules of the land registry. We can now apply this framework to determine the outcome for Premier Finance regarding Fiona's defaulted units. Because Mercantile registered their mortgage before Premier, Section 48 dictates that any attempt by Premier to sell is subject to Mercantile's prior charge. If a sale proceeds, Section 105 distributes funds to Mercantile first, then expenses, then Premier. In Unit 1, Fiona's unauthorized new lease means Premier isn't bound and can evict. But Unit 2's prior lease is a Schedule 3 overriding interest, so Premier cannot evict. Since an occupied sale often reduces the property's value, Premier may instead choose to appoint a receiver under Section 109 to collect the tenant's rent and apply it toward Fiona's debt. Resolving mortgage disputes requires tracking the timeline of registration, identifying statutory triggers for remedies, and mapping proceeds against the legal hierarchy.